Hello my friends, let's talk again about the Illinois assault weapon ban. I want to talk to you guys about some updates, some things that have happened in the last few days since the ban has passed. We're going to walk through, talk about what we call nullification. We'll start there. We're going to talk about some court cases. It's already being challenged. We're going to talk about some of those court cases. We'll also talk about, I'm going to give you, some of the frequently asked questions. There was a lot of questions on the last video. Some of that was my fault for not explaining it as well as I should have, so we'll go through the frequently asked questions. We'll also talk about some of the myths that I've been hearing that, some of them are absurd and some of them are, understandable. Such a poorly written law, why we might have misunderstandings. Of course, I'm not a lawyer. Nothing I say is legal advice. It's just my interpretation on how I'm looking at it. So, first, let's start with nullification. Many sheriffs, in fact, the majority of sheriffs, as high as maybe possibly 90 sheriffs in the state of Illinois, are refusing to enforce this ban. And actually, let me take a step back and say not just the sheriffs, the county. Okay, so that could be the sheriffs, it could be the state's attorney, and it could just be the county board members. Now, I'm encouraging anybody who lives, and we're going to put the maps up there. There's two maps. I'd like to know who to give credit to these two maps. I didn't make up these maps. If you know who originated these maps, leave a comment because I'd like to give credit. These maps show the counties that have some sort of resolution, or the board or the sheriff or the state's attorney has made a statement that they are not going to enforce the Illinois assault weapons ban. I'm encouraging all of my students to basically proceed with caution. Obviously, a county board doesn't make rules for the sheriff nor the state's attorney. So unless the sheriff and the state's attorney have both made statements, then of course you can always be arrested. Also, you can be arrested for anything, right? That guilty till proven innocent. If they change their mind, I would hate for you to get caught up in the mess. We're seeing a lot of political theater on this from both sides of the aisle. So be careful, okay? Very likely the further away you get from Chicago, the less likely it is to be enforced. But if you are in a purple county, then you really need to support the people who are supporting your right, because again, these board members, these sheriffs, these state's attorneys are putting their political career on the line to defend your right, to honor their oath that they have taken to uphold the Constitution, and they're going to need your support come election season. And voting alone might not be enough. You might need to get out there and knock on some doors and help them campaign, and that's something that you really might need to do, because some of them are really under attack right now. So that's nullification. Take a look at those maps that I just put up on the screen. See if your county is one of them. Then I encourage you to seek out the resolutions and read those resolutions, read those statements for yourself. All right, let's talk about some court cases. Now, I'm updating in real time the court cases on our website. As of right now, I'm tracking 4 cases, and in fact, this morning, I'm recording this Wednesday evening. You're going to see this. We're going to post it and publish it on Friday evening. This morning, one of those court cases is already heard in Effingham County Court. We expect a resolution, we expect a judgment on a temporary injunction. That's what they're asking for to start with, is a temporary injunction. And we're expecting to hear possibly on Friday. So I'm not going to be able to update this video. You need to check our website. The link in the address will be a direct link to our website explaining all about the assault weapon ban, including all the court cases that I'm monitoring. So we've got that one. We've got a court case. Law Weapons, in conjunction with the National Association of Gun Rights, has filed a lawsuit. We're tracking that one as well. They too are also asking for a temporary injunction. What that means is essentially, if there's a temporary injunction, then the judge grants and basically says that the state cannot enforce parts or all of the ban. We have to see how the judge rules when they issue the injunction, if they issue the injunction. There is also a court case in conjunction with the Illinois State Rifle Association, with the Second Amendment Foundation and the Firearm Policy Coalition have gotten together, and they have filed a lawsuit in federal court as well. So we're watching all of those cases. These are going to progress, and we're going to update the website. As of right now, even though there's court cases, there's been no change to the law. Nothing really has changed since the last video other than the nullification and the court cases. I want to tell you real quickly about a couple of myths that I've heard. First, it seems reasonable, and I understand why people might have this understanding. I'm not a lawyer. My interpretation is meaningless, but what I have heard some people say is if you have a concealed carry handgun with a rail, you know, if you might want to mount a flashlight or something, you would have a rail, that then would be considered a banned item. They are referencing and they're pointing at the part of the law that talks about the foregrip on firearms. The law says if it has a foregrip, not if it can receive a foregrip. So I don't really believe, in my layman opinion, that interpretation is correct, that you cannot have a rail on your concealed carry pistol. Hopefully the court cases, hopefully there's issued some injunctions and it'll stop all this nonsense and we won't have to worry about that anymore. One myth that I heard that borderline ridiculous is that the new law changes that you can't carry a knife while you are carrying a firearm. And I can't find that anywhere in the law. Someone's going to have to point that out to me. I've read it twice, okay? I read it once originally, and then I read it again when someone made that claim on social media, and I was like, hey, wait a minute, I must have missed that. Nope, I read through it twice. I can't find it. Please point it out to me. Where does it say you can't carry a knife? Gun stores are the original fake news long before CNN, okay? Some of the stuff that I hear coming out of gun stores, as I always say, if something sounds funky, I always say, can you cite the source? Most of the time, it's just something that I heard. It's regurgitated nonsense. Now let's get into some of the frequently asked questions so we can alleviate some of the confusion that people have based upon both, again, my past video as well as we've had a lot longer now to really digest the information. So let's get into those frequently asked questions. The first question talks about, is my, let's say for example, Glock 19, would my Glock 19 be banned? Well, that could just as easily be a Smith & Wesson M&P, a 6-hour 365 or 320 or any of the other common concealed carry pistols. And the question is it banned? Well, the answer is maybe. And I say maybe because the way the law reads is if it is capable of receiving a 15-round magazine and has one of the cosmetic features that are on the banned list. So pretty much any firearm that has a detachable magazine is capable of receiving a magazine of any size. So the bottom line is if it's capable of receiving a 15-round magazine and has one of the banned features. What's typical on a concealed carry pistol would be, for example, a flash hider. That's not typical, but a threaded muzzle. Or if you have a trigger modification that speeds up the semi-automatic pistol, which is very vaguely written, and it could include some kind of trigger modifications. So if it's a bone stock Glock 19, no modifications, no threaded barrel, and the magazine is 15 rounds or less, then you should be fine. Of course, you can be arrested for any reason, but as I read through the law, I see no reason why a standard concealed carry pistol would not still be fine to carry. Keep in mind, if you do have one of those banned features, if it is a 17-round magazine, if it has a threaded barrel, then there's the 90 days after the time that the law went into effect. You can still carry it for now, but 90 days after the law went into effect, which was signed on January 10th, then you can no longer carry after that 90 days unless there is a temporary injunction issued by the courts. I've heard from some of my security buddies asking if their Glock 17 service pistol is banned. Well, there's a little gray area to that question because specifically for licensed security who have the firearm control card, which is the armed licensed security license, in their course of duties, they are specifically exempt, okay, if you are security. If you're not security, though, then it gets a little bit fuzzy because the Glock 17 has a 17-round magazine, and a 17-round handgun magazine has now been banned, okay? So you could not carry around that 17-round magazine after the 90-day grace period expires, so you might need to put some limiters in the gun if you wanted to comply. or buy some magazines that are 15 rounds and happen to fit. So again, if you wanted to comply, those are your options. Again, no threaded barrel, no muzzle flash hiders, and no trigger modifications that speed up the trigger. So I don't see anything wrong with carrying that Glock 17 if the magazine complies with the state law after that 90-day window elapses. Another big one is specifically the Ruger Mini 14. The law actually says that the Ruger Mini 14, the tactical, is banned. But then that leaves us the question, is the ranch-style Ruger Mini 14 banned? Well, if it has the cosmetic features such as the pistol grip and the flash hider, then yes, it would be banned. However, if you have a ranch style, which is the traditional stock, doesn't have a pistol grip, then in my layman opinion, so long as it does not have a flash hider, does not have a trigger mod, does not have a barrel shroud, then you could get away with it. It would not be banned. I probably got more questions about the Ruger 1022 than any other firearm, to be honest with you. The Ruger 1022 is not exempt from this ban. If it has any of the other cosmetic features, then it would fall in the ban list. And no, there is no exemption for 22 long rifle ammunition or 22 long rifle rimfire firearms like there was in previous bills. This bill does not have an exemption for a 22 long rifle except 22 long rifle firearms, 22 long rifle rifles that have a tubular magazine. Otherwise, you know, if it has a detachable magazine and it's semi-automatic, it would fall under the ban. So again, 22 long rifle firearms specifically were asked. Many people have asked about that. And just a reminder, as I just said, there is no specific exemption, a blanket exemption for 22 long rifle firearms. If they have the cosmetic features, they're going to fall within the ban list. Reading word for word what the ban says, a semi-automatic rifle that has a fixed magazine with the capacity to accept more than 10 rounds except for an attached tubular device designed to accept and capable of operating only with a 22 rimfire ammunition. So again, that magazine would have to be tubular to get that exemption on the 22 rimfire. A lot of people have asked, I am not a resident of Illinois, I perhaps live in Wisconsin, can I bring my banned firearm into Illinois? If you wanted to comply with the law, if you're in one of those counties that is planning to enforce the law, like Cook and Lake County are planning to enforce the assault weapon ban, then Illinois law allows you a 24-hour exemption to bring a banned item through Illinois. Okay, again, it's only a 24-hour exemption to bring that banned item through Illinois. It must be unloaded. Any non-resident who transports within 24 hours a weapon for any lawful purpose from any place where the non-resident may lawfully possess and carry that weapon to any other place where the non-resident may lawfully possess and carry that weapon, if during the transportation the weapon is unloaded and neither the weapon nor ammunition being transported is readily accessible or is directly accessible from the passenger compartment of the transporting vehicle. In the case of a vehicle without a compartment separate from the driver's compartment, the weapon or ammunition shall be contained in a locked container other than the glove compartment or console. This verbiage is very familiar to the Firearm Owner Protection Act. That's pretty much what they copied in regards to the non-resident exemption. A lot of people have asked, can I go out of state and buy another firearm? We know that federal law allows people to go out of state and buy long guns at gun stores. And Illinois law specifically says you can buy a long gun at a gun store so long as it's the contiguous state sharing a land border, Wisconsin, Iowa, Kentucky, Missouri, Indiana. All right, but federal law also says that the gun store has to follow the laws of the state of where they live, so it's very unlikely that the gun store will transfer you a firearm if they understand that that firearm is banned here in Illinois. I do have a friend who runs a gun store in Wisconsin, and he's specifically contacting the ATF to get basically a permission or denial, so to find out if that process is specifically legal. So I'm saying right now probably not. I think you're going to have a hard time doing that. If it works out, then that's great. But when we look at the way the law reads, you'd basically be importing a banned item, and that is against the new assault weapon ban. Here's another one. Aren't the guns that I already own when I bought them, aren't they registered? The answer is no, but yes. And I really need to explain what that is. No, technically firearms are not registered in Illinois. Yes, when you buy a firearm, you're filling out a federal form. It's asking a lot of questions, your name, your address, even your social security. That's the federal 4473. Every gun store is going to have you fill out that form. However, that's technically not a registry because that information is not transmitted directly to any sort of department except upon the request of a law enforcement department. So it is a registry, but it not really is a reverse registry. What they need to do is, let's say for example, a firearm is found at the scene of a crime. They know the manufacturer, they know the serial number, and the local police will reach out to the ATF. The ATF will contact the manufacturer who can trace who they sold this gun to based upon the serial number. They sold it to the ABC distributors. The ATF contacts ABC distributors. Who'd you sell this gun to? We sold it to XYZ gun store. And then either the ATF or the local police will contact XYZ gun store. Who'd you sell this gun to? Well, I sold it to John Smith. And that is how they do that. Understand that whenever you purchase a firearm, there are a couple background checks taking place. The federal level, the NICS, National Instant Check, and the FTIP, FTIP, Firearm Transferee Inquiry Protocol. The NCIS is the national check, the FTIP is the Illinois check, and it's reasonably assumed that for every background check you've purchased one firearm. No, there's no guarantee. You could have done a background check and never taken possession. That's true too. But it's generally assumed that every FTIP you have a firearm. Okay, so that means that the government, both at the state and the federal level, have a guess as to how many firearms you own, but they don't know exactly how many firearms you own. If they really wanted to find out, the Illinois State Police can simply contact the gun store and say, there was an F-tip on November 11th of 2022. That was for John Smith. We need to know what John Smith purchased. And of course, if there's multiple F-tips, they can do it that way. So the bottom line is if they really, really wanted to know, they could find out, but it's going to take effort on their part to find out. That is technically not a registry, but it is a reverse registry. The government's just trying to make it easy on themselves. They just want to know what you have, and that really is the bottom line, why they're pushing so hard for this registry. Are incomplete or stripped receivers banned in Illinois? In my layman opinion, if that receiver was purchased before the ban went into effect, then no. But I do think you're going to have a hard time buying a new receiver if you wanted to get one. The reason being, the way that the law is written, it says it bans parts and pieces that can be assembled into a firearm, right? So obviously a receiver, the whole point is to assemble that into a firearm. Obviously, yes, you could assemble a compliant AR-15 that met all of those cosmetic requirements. It would be a pretty gimpy firearm, but it could be done with something like a Monster Man grip and a fixed magazine and no front barrel shroud, no handguard, nothing like that, no flash hider. It could be done if you really, really wanted to. The problem is the law also bans the parts and the pieces to assemble that firearm, so if you don't already have the parts and pieces, it's going to be a hard time to get that. The law reads, all of the following rifle copies, duplicate variants, and altered facsimiles with the capacity of any such weapon. They list hundreds of them. So if it's an AR-15 clone or an AK clone, if it's a receiver for an AR or an AK, that's going to be banned. The law also states, assault weapon attachment means any device capable of being attached to a firearm that's specifically designed for making or converting a firearm into any of the firearms that are listed in the banned section. Obviously, a receiver is going to fall within part or a piece that can be converted into a banned firearm. A lower parts kit, if you don't already have it, that would fall underneath the ban as well. I know, for example, RSR Group, which is one of the largest distributors in the nation, has already ceased the sale of parts and accessories to Illinois residents, okay? Many of the parts and the pieces to build a firearm, if you don't already have, you're going to have a hard time getting. RSR Group is the distributor that many drop shippers use. A drop shipper is someone who does not have inventory. Instead, they let the warehouse, the distributor, have the inventory. They will market and sell the product, and when you place an order, often automatically that goes straight to the distributor. Sometimes the drop shipper will manually enter the order themselves, but usually there are quite a few services where the order goes directly to the distributor and it's automatically fulfilled, and you might even get a label with the drop shipper's name and address on it, but it's coming out of the distributor's factories. So if the largest or one of the largest distributors is saying they won't sell parts or pieces, that's going to really reduce the amount of availability for parts and pieces. But then again, we also have to understand that if we were to go out of state, let's say numerous people have said, well, I'll just go to Indiana and buy magazines. That might be fine. You're going to spend more for gas than you will for a PMag, but also you would then be importing a banned item, and that's not good. Can I sell the banned items that I currently own? The answer is yes and no. Yes, if you're going to sell those banned items out of state. Yes, if you're going to sell those banned items to a gun store. It seems to me, in my opinion, reading through the law, that that's allowed. We do know that the law banned the sale to private individuals when it took effect. Now, there's some discussion about the way that the law is written, and everyone agrees it's poorly written, but there's some discussion, and I'm choosing to take a neutral stance. There's some discussion that if, and just again, the way the law is written, between October and January, that it actually would be allowed. So from now to October, no. October to January, yes. I'm sure that wasn't the state's intention when they wrote the law. Again, it's very poorly written. I'm kind of on the fence. I'm taking a neutral stance. I'm just letting you know that that is something that is being discussed and kicked around. Reminder, you can be arrested for any reason at any time, and you are guilty till proven innocent. That's not the way it's supposed to be, but that's the way it is. Again, just to refresh, you can sell it out of state if you wanted to. You can sell it to a gun store if you wanted to. Before we close out this video, I want to talk to everybody, the many of you who left a message on the previous video saying that they shall not comply. Non-compliance is all well and good. I had one person mention, he said, I sound like a coward. Listen, the bottom line is it's my job as an instructor to give you the information that you need to make an educated decision. I know where my line in the sand is drawn, and I know what I'm going to do. You have to make the decision that's right for you and your family. But if you choose not to comply, I want you to know that non-compliance alone is not enough. Non-compliance kicks the can down the road for future generations if we, our generation, don't fight this. And that's what we need to do. We need to support the gun groups that are challenging this law. As I said, there's multiple lawsuits filed, and there's going to be a few more filed. Go to our website. Support the gun groups that are spending the money to challenge this law. Because if the law stays on the books, it eventually will be enforced. I'm convinced, based upon conversations I had with the old-timers, 1968, the FOID Card Act passed. In 1968, many people silently did not comply. In 1968, many officers silently did not enforce. And nowadays, it is the law of the land. It is readily enforced. People are going to jail for not having a FOID card. It is the law of the land, like it or not. That's not the way it should be. It's unconstitutional, but that's the way it is because past generations did not fight to remove it. They didn't comply, and they kicked the can down to our generation. We need to fight this law to have it removed from the books. I would imagine almost everybody who watches this channel has a strong interest in self-defense, but we have to protect our right to self-defense, and we have to do that right now. Don't kick the can down the road to future generations. As always, everybody, be armed, be trained, and be alpha. I'll catch you on the next video.